Yeah, well, welcome everyone. This is the Brisbane Internet Meetup. I see a few new faces in the audience. Thank you for coming along. If you don't know who I am, my name is Aaron. I run a small web hosting company here in Brisbane, and I've been co-organising this group for maybe even more than a year now, but I've been coming along to this group for probably 3+ years. So it is quite a mature group. As you've probably seen on the meetup, there's over 600 people registered on the meetup, and we've got a little bit of a good turnout here tonight, which is good. Tonight I'm very privileged to have a guest speaker who I asked to come and speak at our group last year, and for one reason or another we were just very, very busy. And it's Kay from idealaw.com.au, and she's here tonight to talk to us about legalities of running an online business. Now, I must confess, I've been in the game for a very long time. I'm still a bit hazy on the legalities of actually running an online business, what sort of bits and pieces you have to have on the website, how do you back yourself up, and so I'm really looking forward to what Kay has to say. So I'll turn the floor over to Kay, and she's going to run it through with us. After that, I will ask, before Kay begins, if you've got a phone or some device that makes a noise, can you put it onto mute? And Kay will talk for probably about 45 to an hour with the presentation. Then we'll take Q&A with Kay, and then we'll just break and mingle and have a Q&A for ourselves. Meeting closes at 8:30, and we'll just disperse. Righty, okay. Take it away.
Thanks.
This one there. I'll just lock that off.
Okay.
In the pocket.
Brilliant.
All good.
Okay. Today what I'm trying to cover is a bit of an overview of legal issues in running an online business. A lot of these are going to be ones which apply to all businesses anyway. But some of them are just to do with online businesses in particular. And the reason why, of course, you're here is because you want to find out, how can you get sued? And being a lawyer, my answer is, let me count the ways. There's different ways in which you can be sued, and I wanted to just sort of set out here the ways, the sources of where the lawsuits come from. One source is general law. So if there's some sort of negligence involved, in some instances defamation might be under general law. It can be under contract. There's some sort of contract between you and somebody else that has been breached. It might be from legislation. And it can be Australian legislation because you're based in Australia, so Australian laws apply to you. So you've breached something like the Corporations Act, the Privacy Act, something in the Tax Act, something about consumer law, trade practices sort of law. You can have a lot of overseas legislation that applies to you as well. Jurisdiction is something that we'll talk about a little bit more later, but a lot of you are running online businesses. Who's running an online business here? Yeah. And do any of you who are running an online business have data that is hosted overseas, or is it a .com? Are some of your users from overseas? It's targeted at an audience that's overseas. In that sort of situation, you might find that overseas legislation also applies to you. If anyone has any questions at all, just jump in and ask. I don't want you guys to all sit there. So the common sorts of things that I see that go wrong with websites is that the website is, there's something about the content of your website. It's either misleading, or it's defamatory, or it's illegal in some way. You're running a scam, you're running some sort of a illegal investment scheme that isn't registered, and so on. You haven't complied with some laws. You might have used material or information without permission, and this can be material that you've just, well, you thought it was stock images and you've just taken it off some website, you've stuck it on. It might be something quite minor. It might be something quite major. It can be material that you've just copied. I saw a website just recently which had 100% of its content lifted from other websites. So it appeared as a business website, and it had heaps and heaps of stories from, stories about the economy and stories about businesses and stories about the stock market and so on. 100% of the content just lifted straight off things like the Times, the New York Times, the Guardian, and so on. Without any attribution, no authors listed, nothing, no links, nothing. I think they were a scam website, but it does happen. Sometimes people will borrow content from a blog without attribution and so on. Yes?
Okay, copyscape.com is well worth a visit on this very point. You can put in your own domain with some of your own material and it'll find whether someone else has copied it.
Okay, just so you can hear that on the video, Copyscape is a website where apparently you can search.
Yes.
So you can put in your own domain and then it'll search for any of the content from your own website that's being copied somewhere else. That's useful for bloggers, I suppose.
If you're putting academic or different information on and you reference it as to the author and where it's from, is that acceptable?
If you are using material which is academic or papers, so if you're using information from somewhere else, material that's written by someone else, and you give an attribution, you can still be infringing their copyright because you're using it without their permission. So, I mean, we'll talk about what is copyright a little bit later, but in essence, if someone owns the copyright in something, it means that you infringe their copyright if you copy it or you reproduce it. In some cases, even if you reproduce it and change bits of it. Ask Men at Work about this after they took one riff off the Kookaburra song and they got done for it. Even if you change it, even if you do something else to it, even if you use it in a different way, it doesn't mean that, oh yeah, you're fine. There are some exceptions to that if you are using something for personal study, for example. Or us as lawyers, if we print something out so that we can give legal advice. But generally speaking, if you don't own the copyright, you need to have a license to use it. So just giving attribution doesn't mean that you're in the clear. You can get sued for using information of users without permission if you have not asked them for their permission. So you collect user information, their names, their numbers, personally identifying information. You go ahead and you use it in a way that they wouldn't have thought you were going to use it, like you pack it all up and you on-sell it. That is, in many cases, going to be illegal.
What about in the case of, instead of their names, details and whatever, but something they've sent about your product, your business, whatever, they've made a comment to you, is there an issue with you then saying, look what this person said about us?
Okay, so the question is whether or not if someone makes a really complimentary comment about your product or you, can you quote that on your website and name them?
Generally not, no.
Yeah.
Testimonials there, aren't you?
Yeah,
You have to have their permission.
Yeah, generally, best practice would be to ask for their permission. If you're not going to name them, you could put it up there, and particularly if it's something that they've said rather than something that they've written to you, it's probably okay. It's just that as best practice and out of courtesy, I would get their permission. The exception to this is if you're going to name them, and particularly if they're a VIP or a celebrity or something like that, then you are kind of implying that they have endorsed your product in some way beyond what they might have intended when they said, hey, that looks pretty cool. Then you could get yourself into a bit of strife there as well. People get into strife when the users just aren't happy with the services or the products that are provided for one reason or another, particularly if they're paying money for it. And then there's stuff that is outside of your control to some extent. It's like you haven't done anything wrong, but your upstream providers might have done something wrong. So whoever's hosting your website goes down. Therefore, your website goes down. And if it's the kind of website where users come to rely on it because they must buy and sell on it, then you've got a bit of an issue. If they can't access the site when they want to access the site, and it wasn't even your fault. But because you have a contract with your users, you might be at fault to them. On the other hand, you could also be liable for things that your users do on your website, either to each other or to third parties. With this, I'm thinking about websites where you can post comments. And your users go ahead and post something that's really nasty. And it's illegal. It's defamatory, or it incites hatred against somebody, or it's a racial slur, or it's one of those things. Because you are the owner of the website, you may incur some liability. This is an evolving area of law, but there's a case that I know of where Perth Now, the newspaper website, was held liable for comments that a user made to a news story. It's not clear cut because the moderator let it through, basically. So in other instances where the comments are not moderated and the site clearly says comments are not moderated, there's been a little bit more leeway. That's the way it seems to go. But all I can say is that there is a possibility that if you run a website and some user posts something that is illegal, that you as the website owner could foot some liability for it.
I just came across something similar on the new Google Plus Hangout video that's just been expanded. You actually have to not sign, but agree to the terms and conditions that anybody who's on your Hangout, you are responsible for, which I went, wow, okay, that's interesting.
So,
you might have 1,000 people on your Hangout and Google, I don't know if they'll enforce
I haven't read Google Plus's terms. Yeah, I haven't seen that bit. Apparently, Google Plus's Hangouts terms of use say that you are responsible for the people who are in your Hangout. I'll have to have a look at it now because
it's brand new, so.
This is the kind of stuff that I see going wrong. The kind of disputes that people come to me with, and they say, "Oh, look, we're worried about this," or "This is keeping me up at night." This is the kind of the material that I see that becomes the lawsuits. Broadly speaking, it's not an exhaustive list. I'm sure you can think of many more things that can go wrong with a website. But the kind of cease and desist letters about misleading website content or copyright infringement, that's where it usually comes from. So, I guess what I really wanted to talk about is how to minimize it, how to minimize the risk. And a lot of these steps, again, are things which every business should and could be looking at. Whether you're small, whether you're big, whatever size you are at, these are issues that you should be aware of and keep an eye on. And as you evolve, you might be able to address more and more of them. Some of them aren't relevant to you yet. Some of them will become relevant as you go along and as you grow. And basically, I wanted to talk about structuring, how you structure your own business, whether you are a sole trader or not, or whether you have a company or what you're doing. I wanted to have mention contracts with outsiders, that is, contracts with people that are outside your business. And then contracts with people who are inside your business. And lastly, I wanted to talk about intellectual property. So, what's structuring for? Now, if you go and talk to your tax accountant's going to talk to you about structuring as in, here's how you minimize your tax, here's how you split your tax with your spouse who's got no income, or you've got so many kids and this is how we're going to split that. From a lawyer's point of view, for my kind of business and most of my clients, it's about asset protection and separating your personal assets from the risk and the sources of risk. So we've seen some of the sources of risk. So how do we separate our personal assets, the family home, your car, the money in the bank, all of those assets from the risk of running a business? Because you can only ever manage risk. You can't get rid of risk. If you wanted to get rid of risk altogether, you would give away all your worldly possessions and put on a hairsuit and go and live in a cave, basically. Because you would be unsuable, therefore you would have no risk. But once you run a business, you have some risk, and that's the way it is. The worst possible structure, let's start from the top, is a sole trader. It's the simplest, it's got the least amount of expense and the least amount of paperwork, and it is also the worst from a risk perspective. Why? Because you are a sole trader, people are contracting with you personally, all of your personal assets are on the line every time you sign a contract. That's a sole trader. You should not be a sole trader if your business has any high level of risk at all. People do start as sole traders when there's no money or risk in the business. In other words, the business isn't doing anything, and they figure that they can just start light and see if it takes off. And frankly, they're just selling jewelry online or something like that that they hand make in their garage, and the risks are pretty low. That's an assessment for you to make, but from a lawyer's point of view, I would always say, don't do that. Don't do that. Or if you're going to do that and you're going to change over later, don't wait for too long, because this is the snowball rolling down the mountainside sort of thing. When you're little, it's easier to change direction and change structure. As you get bigger, it's harder and harder and harder and harder. Imagine if you're rolling along and you've got bank accounts and transactions rolling, and contracts with suppliers and contracts with clients and things like that, and then you want to change. You're going to foot things like stamp duty, for starters, and then the paperwork of changing every single contract, every single bank account, your business registration, everything over to your business, to your new company. It's not worth the pain. It's incorporating a company is not that expensive. Partnerships are in the same boat. In fact, possibly partnerships are worse than sole traders. The reason why is because you and your partner are jointly and severally liable for the partnership. And that means that not only are you responsible for the contracts you have signed, but also the contracts that your partner has signed on behalf of the partnership. So if they enter into any kind of lease, whatever misrepresentation or lies they have told clients, you are bound by that and you are personally liable. Do not get into a partnership. Instead, a safer sort of structure is a corporation or a company. Incorporate a company, and then the company is considered a separate legal entity. It does the contracting with clients and suppliers and so on. And therefore, if the contract is between the company and your client, and something goes wrong in that contract, the client sues the company and not you personally. That means that your own personal house is not on the line. Look, there's other things that you can do. Trusts, there's unit trust, discretionary trust, hybrid trusts, trust combined with the company, and so on. I don't want to get bogged down with it because I think it's boring as batshit. But there are other options, and most of them are tax driven. When it gets down to that, when it's like, who has the shares so that we can a discretionary income, for example, so that we can distribute income to family members and so on. So have a look at your contracts. Upstream, I've called them. the wholesale contracts with your suppliers and things like that. It's hard to give a really good outline that fits one size fits all for all suppliers. We are running. We've already run it once, and we're running it again. We're doing a half-day workshop on IT contracts, because it takes that long to sort of go through all the elements of a contract and how to do it properly and what to look out for and that sort of thing. So at least you can read a contract and sort of make some sense out of it. But for all of your contracts that are upstream, you've got to identify who your key providers are, because that's where your main risk is. The providers that you can't do without, the providers who are providing you with key elements of your business. It might be the person who's hosting, the company that's hosting your website. They go down, everything goes down. That's a key provider. It might be at the outset your web designer or your web builder, your content writer, your artist, your photographer, payment gateways, hosting, any of those services. If you are someone who's providing hosting, and many of my clients are, then they also have upstream contracts at the back end about how they're doing the hosting, whether it's their own server, whether it's a server that's got a co-location in a data center, and all of those issues come to play as well. So in each of those contracts, you have to say, what are your key risks? What would happen if that key contract went wrong? If the relationship just soured, or if you weren't happy with the services that were being provided? Have a look at what could you do? What rights do you have? What are they promising? Is there an SLA attached so that you can say, wait, you promised me guaranteed uptime of X, and you haven't met it, so therefore I'm entitled to these damages or this rebate or whatever it is that you're entitled to under the contract. Is that strong enough for you? Would that protect you? Intellectual property. I'll touch on this because some of you are designers and content writers and so on. Generally speaking, when you are a contractor and you create something that has a copyright, as a contractor, you own the copyright by default. Okay? If a client has engaged you to design, say, an icon for them, right? Unless the contract says otherwise, you own the copyright in that icon. The client gets a license to use that icon for the purposes that are kind of contemplated in the contract between you. So if it's an icon that becomes a logo for their business, then they've got an implied license to use it for that purpose. They might not have the license to use it for other purposes. And unless the contract says otherwise, they don't actually own the copyright in their own logo. This can be problematic for someone who gets content writers or artists or photographers to create content for their website. They think they own it, but they really don't. They think that they can do anything with it later on, but they really can't. They may be bound by some sort of a license and a limitation in the license, or they may be bound by, they couldn't, for example, get a photograph and then claim that they took it because they're really hot, because that would infringe the photographer's moral rights. You also have to identify another key risk of any upstream contract is when does it start and finish, for example. Basic stuff. When does it start and finish? So if you've got a contract, an upstream contract that you rely on that starts and finishes on these dates, and then you've promised the client something that starts and finishes on this date, you've got a problem. Because 6 months down the track, you'll go, oh, but wait, my supplier my upstream provider has suddenly doubled its prices because the initial contract terms run out, and then they decided they charge me more, and oopsie, I've promised the client this price, and now my upstream provider's charging this much. Even simple things like that, it's really easy to just skip, because you go, well, everything's running fine. and unless you sit down and make sure that everything coordinates, you can get fried. Liability is another one. There might not be anything that you can do about it. A lot of contracts are take it or leave it sort of terms, and most, particularly mass service providers, if you like, they're so big that they sort of go, we're not liable for anything, thanks, bye. And it's up to you as to whether or not you accept that. And the question will be, what level of liability do you have to your clients, and will you get stuck left holding the bag in the middle? Jurisdiction is another funny one. If you are engaging people who are overseas, and they're hosting, your hosting is whether your hosting is overseas or something like that, the jurisdiction may be overseas. So if anything were to ever go wrong, you find that a different set of laws applies that is not Queensland law, and that you'd actually have to go to Florida or wherever they are, or Bermuda, to sue them, which isn't really practical. As I said, we cover this sort of thing in a lot more depth, but it's a 3-hour workshop, and people come out of that going, my brain's fried. So there is a lot in there, but I just wanted to sort of hit some of the highlights. Contracts for downstream. I'm talking about your contracts with your users. So in other words, for websites, your terms of use for your website. To be honest, usually I often get asked the question of, can I just write up the standard website terms for somebody? Just give me the standard, and just, I'll just run it off the template anyway. The answer is, it depends very much on your business, and I see so many innovative websites that are doing new and inventive things and interacting with people in new and inventive ways, that it's not really enough for me to just roll off the template and say, here's my standard terms. Because what your standard terms should do is it should reflect your business model. So start with your business model when writing your terms, if you are determined to write your own terms. Although, lawyers are very nice people. But if you are determined to write your own terms, start with your business model. Identify what does your website do? What are your users allowed to do on the site? What might they do with the website content? What do you want them to do? What restrictions do you want to put on them? If it's payments or something like that, what if they don't pay? What if they pay late? If there's something to be shipped, what happens if, through no fault of your own, Australia Post takes forever to ship it, or it gets lost, or it gets damaged? What if you have a dropship sort of arrangement where a user from the US, and I had this happen, a user from the US would log on to a .com website, buy a product, and as soon as it was ordered on the website, the payment would come to the Australian business owner, but the supplier of the actual product physically was also in the States, and they would just drop ship it to the end client, right? Drop shipping. That was fine. My client, who was a really nice lady, said to me, I want to be fair to all of my customers, and I want to give them an ironclad money-back guarantee if they don't like the product. I said, that's lovely. Let's have a look at what your suppliers are promising you. And she had 3 different suppliers, all based in the US. 2 of them had no money-back guarantees at all, so you couldn't do returns unless One said no returns at all. One said only returns if damaged, and the last one said they would only give a limited amount of returns for certain restrictions within so many days, but you had to pay the return postage and so on. I said, so what's going to happen? Someone orders shoes or whatever. They find that they don't really fit. They want to send it back. They send it to where? To you in Australia or to your drop shipper? Either way. They demand a refund. They send the product back. So you have to pay for the refund, and you pay for the postage back for the return. Your drop shipper goes, no, we're not taking the return. They send it back to the customer, and they still charge you. So then you have to pay your drop shipper supplier. So then you've paid the refund, you've paid your supplier, and you've paid postage there to there to there, 3 times the postage, for every time somebody changes their mind about a pair of shoes they bought. Is this what you would like to do? And she went, yeah, maybe I might not be so nice to my customers after all. And that's what it's about. It's about going through your business model bit by bit, saying, where are my risks upstream, and what am I doing for my users downstream? And coordinating the two, so that you're not left holding the bag. Whatever it is your suppliers are offering, try not overpromise to your customers. Unless you're getting paid a mozza, in which case, yeah, sure, go ahead. Because you can foot the occasional bad transaction if you're really being paid so much that you still cover it and you just factor it in. So there's different types of users. There's casual users who are just people who are browsing the site, and usually these days I commonly see websites which have some sort of registration process. Once you register, you can see more content, or you can see you can do more things on it, or you have to register to leave comments or post things on post information, whatever it is that you're allowed to do. So you can see that there's different types of users, and they have different sets of permissions. So you wouldn't always have one set of terms that covers all of your users. You'll have one set of terms that just covers the basics of, if you're a casual user, you give, again, there's a difference between what you're by law obliged to do and what is best practice. What you should be doing as an Australian business owner is identifying the owner of the website somewhere in the terms. So if like quote your ACN or your ABN, in other words. If you're collecting personal information, it's a good idea to have a privacy policy, although the Privacy Act does not apply to all businesses if they're very, very small, depending on what you're collecting and so on. You'll step it up again for paying users because they're paying. You'll have another set of terms. If your terms will be different for advertisers who are another kind of user. They are a user. But for your advertisers, for example, you'll want to say, you might want to give yourself veto power over their ads, because otherwise you'll see all sorts of stuff turning up on your website that you sort of go, I didn't think that that's what you meant. You know, when you said that you are a business advertising shoes, I didn't think you meant that. Or you might object to the nature of the ads. You might say that that's too explicit, or this is a website that's family friendly and we don't want that on our site. You might want to even do simple things like change the layout or shape of the ad from time to time, or rotate ads, or edit in some way, or ask them to, hey, this is not working out, or we didn't like the format, or whatever it is about an ad. So there's another set of terms that applies to advertisers. Very importantly, advertisers should take responsibility for absolutely everything that they have in the ad, because you don't want them to post an ad that's fundamentally misleading. So that's right. As I said, you sort of look at what are your users likely to use your website for? What sort of things are they technically allowed to do? Like, from a, what sort of functionality does your website have? So what could your users be doing on your site? And then, is that reflected in your terms? What sort of restrictions do you have to put on them, if any? What laws apply? This goes back to jurisdiction again as well. If your laws are from overseas, you want to say whether or not Australian laws apply, the laws of their state apply, or their country apply, or a mix, or what. And then the copyright infringement and defamation by users. Users should take responsibility for the stuff that they post on your site. That is not a get out of jail free card for you. You can put it in your terms that you are absolutely liable and I'll come over and break your knees if you do the wrong thing on my website. It does not mean that if they do the wrong thing and you don't do anything about it, or you don't moderate, or you don't do the, or you know that they're doing it, but you say, hey, hell, we're the Pirate Bay, we're going to keep rolling. It doesn't mean that you've got a get out of jail free card. Again, it's about minimizing risks. So whether or not you think that Mega Upload is Kim.com is guilty or not of infringing copyright, the argument is that his users were using his website to share files, many of them illegally. If he knew about it, should he have done something about it? Did he have a duty to do something about it? Does it matter to him now? He has to fight that case, but do you want to be put in that position where you are hounded by the authorities and arrested and so on? It's about minimizing the risk for yourselves as well.
If you're on a .com domain, does that mean that basically would any complaint from American individuals or authorities, could that just go straight to your domain via US law?
So if you are a .com, does US law automatically apply?
Especially with regards to taking the domain away from you.
If you ask the US authorities, the answer is yes. You are still going to be under Australian law because you are here in Australia and you're an Australian-based business. But certainly the US authorities have been trying very hard to say that they've got some jurisdiction over websites by virtue of the fact that they are .com. Which is why Mega Upload, the Kim.com is a German national residing in New Zealand, and the website itself is hosted in Hong Kong. And the American authorities had the New Zealand authorities arrest him in New Zealand. Right. So, yes, they are trying very, very hard to cross those international borders. Ultimately, I don't know whether or not they'll succeed in that case, but they've certainly caused him a lot of pain. And the website is down. And meanwhile, there are millions of users, many of whom were legitimate, who uploaded stuff that they wanted to store. They can't get their legitimate data back, which is tragic for them. So,
in terms of taking the domain from you, .com domains are regulated by a US body, so they have rights to that domain. They own the domain, you borrow it, so they can control it. But in terms of content on it and liability because of that content, that's money.
And look, there's also some argument. Similarly, if your servers are hosted, if your material's hosted on a server that's overseas, the laws of that jurisdiction may apply to your servers, which is why a lot of people are balking at cloud, for example, cloud hosting, and then you don't know where your server is necessarily. It's all in some amorphous cloud. Could be hosted in Singapore or the US or anywhere. Depending on what sort of information it is, You've got some obligations under the Privacy Act in Australia that where you shouldn't be handing it over to a service like that in any case. But if it's highly secure, and if you're a bank, I'd be thinking, yeah, you know, if I found that the Commonwealth Bank was hosting stuff with Amazon Web Services, I'd be a little worried about my financial information being hosted at God knows where. Yeah, so, you know, as I said, it's all about balancing the risk for yourself as well, and sort of going, how high profile is the risk on this, and what are the benefits of doing it that way or not. I wanted to look at internal contracts. This isn't something that normally leaps to mind when we talk about risk and risks of running a business, but in practice I find that it accounts for a high percentage of the businesses that go down. It's because internally they haven't decided what the agreements are between them, that is, between the actual business owners. Normally the issues, the hot issues for business owners are who owns it and how much, and who owns what sort of shares or what sort of units in the unit trust, and what voting rights do they have, and so on. Control and management on an ongoing basis. So how many people are in a business with another person in some form? Yeah. All right. So then there's ongoing control and management. Sometimes you'll get one business partner who just brought the cash and is happy to just take a back seat and just go, yeah, you run the business. I've just brought the cash, and so long as you guarantee me X return, I'm like cool with that. Go and run it. That is quite rare. Mostly, it's like my typical client is a few guys have put their heads together and started up a business from scratch. They're bootstrapping it, so they're all putting in 10,000 hours each in time, and they're living on peanut butter sandwiches to get a business off the ground. They get to a certain point, and they've never sat down and thought about these issues. So they've got a viable business, and then they go, well, how do we make decisions here? And they've just done it informally, but it's something that leads to bust-ups because they haven't really discussed it. So then one of them decides that, you know what, we need more money, so everybody, if we tip in 10 grand each, then we'll be able to take this to the next level. And one of them goes, nah, I don't want to sell my car. Or they have a disagreement about the direction of the business. We want to go into this. We want to target these people. They don't know how they were going to vote and come to a decision. Or oddly enough, when they actually start making money, then I've had one client, at least one, spectacularly blow up because the first time they landed a big client and there was real money on the table, they're all going, I've been surviving on peanut butter sandwiches for the last year. You know, I want my cut first. and then they busted up. So they never actually got the money, which was a bit sad. They might not have thought about how to resolve disputes. As I said, when you reach a deadlock, how do we break a deadlock? I hadn't thought about it. We're all mates, or even worse, we're spouses. We'll never have a dispute. Yeah. Termination, they hadn't thought about what happens, how to dissolve it. It's this kind of agreement's a lot like a prenup. So it's about at the other end, should you have to dissolve it, somebody wants to go fishing instead, so they just want to sell up and go. But what do they sell up at what price? Say it hasn't even turned its first dollar yet, and someone wants out. What's the business worth? If 1/3 of the workforce is leaving, the unpaid workforce is leaving, do you keep them on as a 1/3 shareholder? Because then the remaining 2 people have to foot all of the work, and one's just gone fishing. then should they still own a third? What do we do? What do we do? If we buy them out, how much do we pay them? We don't have any money, none of us do. Or even if there is a lot of money, well, okay, there's a big pot of money, but how do we split it? How do we value this business if somebody wants to get out? What if someone's unable to work, they're sick, they're retiring, they just hit retirement age. They've been chucked in jail, they've died. What happens then? In the what I would call the worst case scenario is a business partner dies and the business cannot survive because they have no other plan. The shares held by the deceased go to their spouse. You hate their spouse. You cannot work with their spouse. Their spouse does something completely different and can't work in the business. What then? You didn't have a plan. That sort of thing should be at least discussed. It's really hard to discuss it. And again, over the years, I've watched a lot of people go through this process, and they come out at the other end saying, the value of going through this process, as in all of the contracting, the value of sitting down and working out the contracts is not so that they have a contract at the end. The value is so that they've thought about their business model, they've thought about their relationships, they've examined their suppliers agreements, they've thought it all through, and they know where they're headed, and that's a greater value than the piece of paper they've generated. Any questions?
When you're starting from basement level, is it worth going through all that sort of stuff at the very start, or is it really?
You need to have some reasonable expectation and come to an agreement as to what you expect of each other,
But
at least.
In a contract way, or is it really just?
Yeah, see, that's really hard. Like, I can send you a checklist, for example, that goes through step by step what I would normally put in a shareholders agreement. And it has, how are you going to make this decision? How about this decision? How about this decision? So what are you going to do with this? How are you going to do this? So you can step through all of that together. And even that's of value, even before you set it down. But really, it's good to set it down on paper and sign it off, some expectation, to whatever level of complexity you can manage. Not that you want to, it's overkill to spend heaps of money getting a solicitor to draw one up for you and so on, if you're just really bootstrapping and starting off. But at the same time, having said that, you need to have that discussion. Know what I mean? Like if you never have that discussion at all, it's the worst possible scenario. And I didn't used to be as emphatic about this until I had one client where it was a man and a woman who were not married to each other, running a business, and they built it up from scratch, just the two of them. And he got sick, and they'd always had an agreement that whoever dies, they would leave their shares to the other remaining shareholder, because they knew that their spouses couldn't run the business. So they went, the only way for this company to survive is if you die, I give my shares to you. You die, I give my shares to you. That's fine. But they never set it down in writing. And then he got sick, and because they were also best buddies, they were kind of in denial about how sick he was, and they were hoping that he would get better and hoping that he would get better until he was actually in intensive care. And they rang me, and they said, we've got a bit of an issue. This is the scenario that we've got. Can you do something? Can you do up this agreement that says that my shares, our shares would go to each other on each other's death? And I said, yes, I can. And I spoke to him by phone in ICU, and he was very weak, but he was lucid. And he said, yes, that's what I want to. That's the agreement we've always had, but we've never set it down. So they said, look, it is really serious now. And I said, fine. I got it out the same day. I think within, like, immediately, I just went, fine, we'll just write something up right now. And I emailed it to them for their review. And she took it to his bedside and read it out to him. And he said, yep, that's what I want. So then she rings me up and she says, can you take this document down to him at such and such a hospital and get him to sign it? And I said, no, I can't take this document to a man in ICU and say, here, hold this pen between your teeth and I'll move the paper. Seriously, I mean, look, what I can do is I can send it to his solicitor, and his solicitor can take it down, explain it to him, and get him to sign it. So he has separate representation, so it doesn't look like, I've dodgied it up. Here, sign this. Yep, we're done. Sweet. Now I'll just flick the switch for you. What can you do, right? So I sent it to his solicitor, and I phoned them. I emailed it. I faxed it. And I posted it. And I said, it's urgent, it's urgent, it's urgent. They went, yeah, so-and-so's out of the office at the moment, but I'll leave a message and we'll get back to you. And they didn't. And he died. That was great because in his will, he had actually honoured their agreement by saying that his shares go to her, which was great to see. However, his wife was the executor. And do you think she was in a hurry? Yeah. So suddenly his wife, as his executor, became the person that the remaining business partner had to go to get, checks signed and things approved and the transfer done. And it brought them to their knees because the wife had always suspected that those two were having an affair. So she didn't like that woman. And that's the kind of situation you can find yourself in. The business survived in the end, but it was close. It caused some real heartache for everyone involved. So that is why, after having that experience, I now say that you really must think about it. And to be fair to the person who, to the shareholder who might be dying, you want to be able to compensate their family fairly, without just yanking the rug from under their feet. That's not what this is about. It's coming to an agreement as to how you compensate the family for those shares, and the company can still keep going, or whether or not you are happy for the family to step in as shareholders. Yep.
Could you solve that issue with just getting a third party, like a witness or someone, and getting them both to sign it right there, just to have something on paper? Would that have helped at all?
If they got that agreement signed in the hospital, it would have, but I wasn't prepared to do it. I was a solicitor representing the company, and it was an ethical conflict for me to say that I was going to bring it to somebody's deathbed. Yeah, I just wouldn't do it.
I guess the other thing, a contract's only enforceable if you're prepared to enforce it as well. I've had an experience with a partnership, it was all drawn up, was all neat and tidy, and we believe gave us the control. A partner had a dispute, but it was in the end cheaper for us to just pay him out than to go through the process of enforcing the contract. So.
Yeah, that's right. A contract is only as good as your ability to enforce it. That's true. And that's why I say that the value out of going through this particular contract, most of all, out of any of these, this contract, the value of it is that you have this conversation and you come to the agreement. And hopefully if you're working with people that are fair-minded, otherwise you wouldn't be working with them, that you massively increase the chances of it working out in some way that you expect. That's what it's about. I'm sure people fight about prenups as well, but whether that means that you should never have a prenup and never think about it or not. Maybe that's a bad example because, there's that love is forever and therefore we shouldn't be predicting it to fail. And I'm talking as a divorced person, sorry.
A question, just
Yeah.
if somebody's written a will and then they pass away, aren't immediate family members entitled to 15% regardless of what they've written? Or is
No.
it family law?
No. Wills and estates is a separate area of law, and certainly if you have a will, any of your family members have standing to challenge the will if they feel that they're unfairly dealt with in the will, but there's no automatic they get so much. If you have no will, then your estate gets divvied up according to certain percentages that are set out in the Succession Act, which are probably not what you thought. Okay, so contractors and employees. This is also an internal contract. This is more on the internal contracting. I'm not going to cover a lot of this, except to say that employees are covered by a wide range of employment law, which is a very established body of law. Where people do go wrong is they don't realize that their contractors are really employees for different purposes. They think they have contractors, but they might have contractors who are still entitled to superannuation because of the way that the contract is done, or they may be required to pay payroll tax on those contractors' fees, even though they're called contractors and not employees. You might find that some of your contractors are entitled to workers' compo because, again, of the way that our employment laws work. And you think that they're contractors, so if they get injured on the way to work, then they're not covered by workers' compo, but you find that they are. Yep.
If they're overseas?
If they're overseas, it's possible that some overseas laws may come into play as well in wherever they are. That's too widespread. That's too far-reaching for me to answer here. But with overseas contractors, in practical terms, if a contractor is overseas, it's much harder for them to sue you. So in that sense, you're kind of sort of safer just because they're hardly going to come here from wherever they're situated to sue you in your jurisdiction. Intellectual property, again, be very aware that there is a difference, and as we were saying before, if a contractor creates something that has some copyright in it, they may own it by default unless the contract says otherwise. It's different for employees. If an employee creates something in your business that's part of their duties, then you own it as their employer. So if I am a website developer and I have 10 people who are employed by me to write code, and they write the code that I instruct them to write, I own the intellectual property in that code. However, I may not own the intellectual property in code that they write in their garage late at night in their own time on their own laptops. Right? Unless that's part of their employment contract. You know what I'm getting at? Like, it depends. If they create something that's within the ambit of their employment, then it's probably going to be owned by you. If it's outside the scope of their employment, it's probably going to be owned by them anyway, even as employees. There is a difference between sometimes when you have a contractor, you put a lot of the liability on them for what they do. You can do that a lot more with contractors, than you can generally with employees. Be aware that your insurance will also work differently between employees and contractors. So examine your insurance. If you've got something like public liability insurance or professional indemnity insurance, check whether it covers employees or contractors or both, or in what form. I'm going to. We're on the home stretch. I can see a bit, but I wanted to talk about intellectual property. And does anybody have questions about IP in general to start off with at all? No? Okay. I wanted to start off with types of IP. Most of these won't matter to you much, but copyright is something that arises automatically. It doesn't have to be registered. You write something, you own the copyright in it. You cannot have a copyright over an idea or a fact. So if I want to write a book about a boy who discovers that he is a wizard and goes to wizard school, that's okay. I can do that. But the more it looks like Harry Potter, the more likely it is that the wrath of J.K. Rowling will come down on my head, and she has the lawyers to back it up. You cannot copyright a fact. So the sun is shining, it is 32 degrees today. You can't copyright that. You can't go, I wrote that first, nobody else can write it today.
What about sports scores?
Sports scores are a really funny thing, actually, yeah. And generally speaking, the raw fact that Team A won or Team A lost, or here's the scores, are not copyrightable because it's a fact. But the gameplay, the taping of the game, for example, the broadcasting rights to the game, those sorts of things are. Yep.
Cadbury's owns or claims rights to a particular colour purple, and Harley Davidson claims to own the sound of their motorbike.
That's a trademark. That's a trademark. Okay, so Cadbury claims to own the colour purple, although they, I think, have now lost it, because Darryl Lee says, hey, we also use purple, thanks, and we have done for a long time. Harley Davidson has trademarked the roar of their engines. Now, that's a trademark. So there's trademarks which are registered and unregistered. An unregistered trademark is just like a brand that you might be using, a brand name or something like that. You haven't ever registered it. That's an unregistered trademark. Yep.
What happens in the case of, say, a logo that changes over time? The person A has designed it 20 years ago, person B comes along, updates it, does this, does that, rah, rah. It's effectively the same logo just being updated. Who owns it?
Okay, so if a logo is updated, who owns the logo? If I update the Coca-Cola logo, do you think that I'll own it?
No, but as
no.
in part
So,
of the business, yeah.
so if the same business owns a trademark and it updates its logo over time, the business still owns the logo. It may not own the copyright in the logo, right? Which is a different issue to the trademark. Okay, so let's draw that little distinction here. The trademarks, you can register a trademark so that the website to look at is ipaustralia.gov.au, where you can search all the trademarks register and whatever's registered as a trademark. I think we'll go into some more information about trademarks later. There's patents which are also registrable. They have to meet certain steps. They have to be innovative or inventive and so on. It costs a lot to register. It takes a long time. But if you have a registered patent, it means that nobody else can use the things that are in the patent. So, for example, it's hugely important to the likes of Dyson, who make the vacuum cleaners. So nobody else can make the same engine to his vacuum cleaners as he does because he's got a patent on it. So others can copy, bagless, this and that, but they cannot make it in exactly the same way. Confidential information, which is, it's a form of intellectual property. It's difficult to prove and difficult to define and protect, but it can be if you define something as confidential and say you can't disclose it. That's what non-disclosure agreements are for. Trade secrets are along the same lines. It's intellectual property because it is so secret. And everybody knows that it's secret, so your employees know that it's a trade secret, so then they know that they're under an obligation not to disclose it, and that's the kind of protection you have. Domain names. I've stuck domain names in there because of what the business that you guys are in. It's a form of intellectual property, I think, because it's so important and it underlies a lot of your businesses. It's closely aligned to trademarks, though, and we'll have a look at trademarks. We'll have a look at trademarks later. I wanted to have a look at, so intellectual property within any business is a really important component because for most of my clients, you walk into the office and you sort of see a bunch of laptops and battered desks, and that's about it. And you go, okay, you guys, your stuff isn't worth much. It would go on Grace Online for like $10, but your intellectual property is what's worth a lot. So for all of you, you need to think about the intellectual property in the stuff you make. What is it? Who owns it? How do you define it? Who needs to use it and what for? Will you ever need it again? So if you've got client contracts where you go, hey, you know what? Once you pay me, you own the IP and everything. Thanks. See you later. Bye. And then you want to reuse it for the next client. Actually, you might not be allowed to. On the other hand, do you say to the client, hey, you know what? Once you pay me, you have a license to do whatever you like with the stuff I've given you. And then they go and use it in ways that you didn't expect. And they set up a competing business against you, using your own stuff against you. Did you think that they were going to do that? Yeah, we didn't think they would, but oops. So what limits do you want to put on users? And how will you know if they've complied? The best protection is something that's hardwired, and you've got a remote kill switch, and you just kill them off if they disable their software or disable their access or whatever if they breach the terms. Yep.
What about user-generated content? So if somebody using your website creates something and publishes it, your ability to use that to promote your website?
Yep, and that's the intellectual property and the stuff you use. So the stuff you use, which is made by other people, again, you have to go through the same steps. Who owns it? What are the limits of your license or permission to use it? Who gave you that permission? Are they authorized to give you that permission? The user who uploaded the content to your website, did they have authority to do that? Or are you just infringing somebody else's? I don't know, well, it probably isn't important anyway. How do you track your permissions? Do your permissions or licenses have an expiry date? Or some limits on use? You can only use it for so many websites. You can only use it for so many users. You can't sub-license it. So you can't take user-generated content and then use it on another website and then give it to somebody else to use for their website, for example. So just because a user uploaded some of their own art, does that mean that you get to print T-shirts with it? Mugs? Trademarks, and I think we're out of time, are we? We're out of time for 3 minutes. Okay, trademarks. So there's a difference between a trademark, a registered domain name, and a registered business name. A registered business name, most of you will know, that is something that you have to register in order to have the legal right to operate under that name. For example, I don't operate as K. Lamb McLeod. I operate as Idea Law. Therefore, it is a registered business name, which is required by law. However, it is also a domain name, and it is also a registered trademark. Those three things are completely different, because if I only registered the business name, that would give me the legal right to use it, but it would not stop somebody from, say, Perth, setting up themselves as Idea Law and competing against me. They can't get an identical registered business name, but they can add another something to it, or it's something similar, or it's Ideal Law and Associates, or it's Ideal Law and something. So long as it's not identical, they'll still be able to register that name, even as a company name. Same with the domain name. Trademark is the only way that you can, by registering a trademark, it's the only way that you can get monopoly rights to use that particular name in Australia, or throughout other countries if you also register in those countries, but that's another step up and quite complicated. So it is worth registering a trademark. It doesn't cost much. It takes a long time. but you can still use it as an unregistered mark in the meantime. Once you've put in your application, even before you put in your application, you can just use it and then go through the registration process. Not everything is registrable. If I start making orange juice, I can't go and register the trademark for orange juice and then go, haha, you guys, nobody else can use orange juice because I registered it as a trademark. The IP Australia would just go, mate, you sell orange juice. Yeah, you're not going to get the trademark for it. It just describes what you're selling. Same if I go freshly squeezed orange juice, really sweet orange juice, orange juice. No, won't get it. It just describes what I'm selling. I also won't get it if there's somebody else on the register who's already got it. However, if I'm doing a line of shoes and I want to call them orange juice, that's fine. Orange juice does not describe shoes. I'm in the clear. So then the next step is, does anybody else have orange juice shoes? And if they do, then I'm done, like a dinner. But there are a lot of different categories of goods and services, 45 of them. On IP Australia's website, you'll find the whole listing. And so you might be able to have orange juice shoes and somebody else has orange juice nail guns. And they don't cross over. IP Australia will let them both on. Therefore, you will see many marks which have the same or similar sort of name but on wildly different products, and that's okay. But if obviously if someone had orange juice shoes or a related item, then I wouldn't get it. So yeah, look, have a look at IP Australia's website. You can see all of the information that I can see when I do a search. The only advantage that I have over you guys is that I've done a lot of them. But and you sort of get a feel for what they're looking for. But you have access to all of the information, and the site's really, really user-friendly and detailed. So have a look. Have a look. Yeah.
And say you've gone through the process of doing it yourself, gone registered and tried, and they've sent back that they want to see proof of how you've used the name. How extensive do you go in trying to prove how you've used the logo or the picture that you want to use?
Okay, if IP Australia has an issue with your logo, and they might say it's a little bit borderline, bit descriptive, and we need you to show us how you've used the things so that if you've used it a lot and it's quite a famous mark, even though it's a little descriptive, you'll push it over the line, for example. It all depends on how much information you have. In circumstances like that, I've just gone through archives for clients who have used a mark for 10, 20 years and just gone through their entire file archive of newspaper clippings and past old old business cards that they had, the old letterheads, photos of their old shop, you bet, yeah, everything. Gone into the Wayback archives and had a look at the past iterations of their website, dating back to, back when the internet was young. So you do all of those things to show, and even your financials, your budgets, past tax returns. You can make those things, you can disclose it to IP Australia on a confidential basis. It just depends on how much history you've got and how badly you want it. And what they said, it depends on the grounds on which they want to see the further evidence. Yeah. Yes?
If your website also operates in other countries, will you then have to register it in America, for instance?
So if your website operates in other countries, do you go and register in those countries? I would say yes. The short answer is registering a domain name in Australia protects you in Australia, will not protect you in the US. So if you want monopoly rights to use that trademark in the US, yes, register in the US. There is a system by which you can do that from Australia called the Madrid Protocol application. You can put in one application here. You'd usually start with an Australian application, and based on that, provided that's accepted first, then you can go ahead and nominate a bunch of other countries and pay enormous fees and put in your application for those countries, and then sit down and wait for a number of months and maybe years. What the complexity with with registering overseas is that you have to go through the same hurdles in those countries. So it's accepted in Australia does not mean that you'll automatically get it in the US. Somebody may already have it in the US, right? And although trademarks worldwide, all the countries are signatory to the same convention, which sets out the classes and things like that, there are subtle differences between countries, which may mean that for one reason or another you get bounced in another country even though you're accepted in Australia. Yep.
So if you were rejected in a specific country, but I guess the nature of being an online business, someone in that country will see your website, purchase from your website, is that you're doing something illegal, so you need to, I guess, block that country from being able to access your site?
If your trademark fails in a certain country, if your trademark registration fails in a certain country, it does not mean that your website is illegal in that country. Your website's still legal or illegal if it is an illegal website in that country according to its laws, but not because your trademark's failed. Your trademark is not protected in that country, so it's possible or easier for somebody else in that country to set up something slightly different to your website, but strangely similar, and it's harder to kick them off. You can still trade in the same way that in Australia, even if you didn't register your trademark, you can still trade, provided you've done the, you've got your registered business name or your registered company name and properly filed things in Australia and done your tax returns and, be nice to police when you see them on the streets. And yes. Any other questions?
Oh, yeah. If you've got a domain, say a .com domain, say ideal.com, then but you hadn't registered a trademark in the US or other jurisdictions, would I presume that having that domain for a while would mean that others would find it hard to take it off you?
So if you have a .com domain and you haven't registered a trademark in the US or another country, but does it help you that you have the domain for longer? Is that your question?
Yeah. I mean, is there any chance anyone could take it off you? And alternately, if somebody else tried to set up as ideallaw.org and pretended exactly the same line of business in America, could you
stop them? It would be if I had ideallaw.com but never registered the trademark in America, and somebody else did ideallaw.org and they are based in America, my chances of stopping them are not real high. You'd be under the same rules of, in Australia for .com.au, you'd be under AUDA's rules for domain name disputes. In Australia, in the US, you're under ICANN's. They're sort of similar. So if you are looking at, they're obviously fake and scammers and just using your website to in bad faith, and it's clearly, and you're well, and you're not Ideal Law, who is pretty much unknown in the US, but if you are Coca-Cola or something like that, then yes, by virtue of the fact that you are famous, you'll find it easier to go through ICANN's dispute resolution and get them kicked off as a squatter. I found in Australia for .com.au, having a registered trademark is a really useful tool in domain name disputes, because you've got something that proves you actually have registered rights, you actually are a bona fide business, and here it is. So it's a really useful tool to either to go through the outer dispute process on the strength of your trademark, or even if you don't get to that level, sending a cease and desist and say, look, we got the registered trademark, now bugger off. And that's a lot more effective if you've got a registered trademark than, we think you're doing the wrong thing because we've been going for a long time and, we're really good guys, which sounds a bit feeble. But you got the registered trademark, you actually have statutory rights. Yes?
I was just hearing the other day that with your registered business name, if it's registered in Queensland but you're dealing with someone in New South Wales, you actually should be registering it in the other state too, is that right?
Registered business names up till now have been state-based. So you are registered in Queensland, you're registered in Perth, you're registered in WA or whatever. That's about to become nationalised. So yeah, hold your horses. In a few months it'll be all nationalised and you'll register just once, which kind of makes sense. Any other questions? I don't know when the national names register is going to roll out, but I think it's just a matter of months.
Yeah, I got a letter about it. It's soon.
It's like July or 1st of July or something like that. Yeah, it's really soon.
Okay, did you have something you could put up there so people could contact you, know where to find you? Did you have much more to go?
No, that's it. That's me. So yeah, if they didn't have any more questions,
was there any more
that's
questions for Kay? Because we're right in the middle of question time, or coming to the end of question time. No,
Yeah.
well that's all great.
Okay.
Thank you very much, Kay, for presenting there. I know that was a lot to take in. I picked out a couple of golden nuggets for myself, so I'm sure that all of you guys would have done the same. If not, we've got it on the video, which will end up on YouTube. Did you want to put these slides anywhere, or
I can send them to you, and you
Okay,
can.
right.
Yeah.
So we'll have the slides as well up on the meetup area. And what we'll do now is we'll just thank Kay for coming along and presenting information. And it will just break and mingle now. And in about 15 minutes, we've just got to clear out. So thanks very much for attending. And next.